May I please, Lordship? I had adjournment slate for adjournment of item number 4, Lordship. For adjournment, please after. Daily list item 4. Daily list.
Okay. From the you're for the appellant.
Appellant.
Okay, with consent of the learned amicus curiae for the respond number 2, the learned counsel for the appellant place for adjournment. Prayer is allowed. List after 2 weeks. We have adjourned at 4.
আর আগে সাবজেক্ট আইটেম 8 এখানে অলপ কমিছিল পার্ট পার্ট বলি অর্ডার লেখা নাই এইটো আইটেম মাতিম সিরিয়ালি
Yes, sir.
W15
Oh, GMCH. That's good. You can take it up. If they are here.
প্রথমতে লোক
আসেন না কোনো তো নাই।
আহিছিলে দেখে বাকো গুছি গুছি
এটা
ও এটা রান্নার প্রারম্ভ করি daily list
Item 1 for hearing.
Here the date of incident is Lordship 13/3/2016.
16.
Yes, 2016. Ejahar is of the same date, 13/3/16, by PW1. Son of the deceased and accused. Accused is the husband of the deceased. This is his second wife, aged about 56 years.
But in this case, even if other things are not there, but this leading to recovery of the dhow from the roadside ditch, that clinches the evidence against the appellant.
That was only outside his house.
No, but it is, there's a leading to discovery is there.
But Lordship, two discoveries. One is a chadar.
Confession, the court says did not accept it. But 27 that leading to recovery was found as an evidence. Because the court disbelieved him on the ground that he took a plea of that he returned back home. That means court took it as a plea of alibi and said that that could not be proved.
But there is no evidence or nothing from the prosecution side on that he's lying, Lordship. That Bhagavat Path, that is though is not said by any of the witnesses, but it is not discarded by any of the witnesses also, Lordship. Or although he had taken that which is not by anybody else, but
Because there are cut injuries on the face and hands.
then hand. But this Ejahar said neck is not in the medical evidence. Ejahar said in her head, neck, and hands. So head and neck is not there, only in the face.
Face and hands.
Hand is there, finger is there, Lordship. Head and neck is there, and more so, Lordship, when if we go by the evidence of the prosecution,
You go by it because I am, my sister would not know. You go by your regular way.
Azahar is PW1 had lodged it Azahar. At present, the accused is 83 years lordship, and he is more than 8 years behind the bar from the date of incident. He is in jail lordship. I start from the Azahar lordship. This is paper book page number 4 is lodged by the son of the accused and deceased. Humble submission is that on 13/3/2016, my mother was assaulted in my absence, and as injury was caused in her head, neck, and hand, she succumbed to those injuries at about 7:30 a.m. at medical. It is therefore prayed that your good self has been informed of the matter by lodging this Azahar and obliged. So here no name is there, although from the evidence it is that they were aware that the accused had assaulted his wife. That is the allegation, but no name is there, lordship. PW1, the informant. Accused Sri Prafulla Chandra Kolita is my father. This is Putuli Kolita was my mother. On 13/3/16, while I was at Joint Sagar in a rented house, on that day my parents live in our village residence. On the date of incident, at about 4 a.m., one of my cousins named Sorubhai alias Rajen Kolita has rang me and told that my father has killed my mother and requested me to come early. At my request, 108 ambulance was called and my mother was brought to Joysagar Civil Hospital, and I also reached hospital. I have seen my mother in emergency ward of hospital and she was alive. I saw injury mark at the head, finger below knee. On my inquiry, my mother had uttered the words that my father had assaulted her. After 2 hours, my mother expired at the hospital. On this incident, I lodged one FIR at Anguri police station, so-and-so is my signature. Police came to hospital and conducted inquest on the dead body. Exhibit 2 is inquest report. My father has surrendered at Anguri police station and OC Anguri police station has informed about the matter to me over phone. Police also visited our residence. Cross. Police interrogated me on the date of death of my mother at hospital. I have lodged the FIR just after the death of my mother. In the FIR, I have not mentioned that my mother had uttered the words that my father had assaulted her. In the FIR, I have mentioned that my mother died in the hospital due to assault on her. It is a fact that while giving statement to police, I have not stated that on the date of incident at about 4 a.m., one of my cousins so-and-so has rang me and told that my father has killed my mother and requested me to come early. It is not a fact that I deposed falsely. Since last 5 to 7 years, I am living separately from my parents. In this period, I did not visit my parents. It is not a fact that about 5 months back, I visited my parents and physically assaulted them. And on this, my father lodged an FIR at Anguri police station. It is not a fact that out of previous grudge, I have deposed falsely by implicating the accused with the death of my mother. PW2 is the doctor's evidence. So here, on same very day, he had conducted postmortem of the deceased and injuries lordship inside wound over face across the nose of size 7 inch, left size 6 inch, inside wound over forehead extending to temporal region, left side size 8 inch, inside wound over lower part of face, about the margin of mandible extending up to the ear, lacerated wound over forehead size 4 inch, inside wound over left leg, lacerated wound over right thumb, incised cut wound on the left hand wrist. Size 3 is bone deep. So these are the injuries found by the doctor, and his opinion is page 12, last paragraph, clause 8. Opinion. In my opinion, the cause of death is hemorrhage and shock leading to syncope. And cross lordship, next page. The inside wound as found on the dead body may caused by exhibit 1 tau shown to me. Lacerated wound may be caused by sharp object if underlying surface is hard. PW3 is Susen Soikia. He is a resident of the same village and neighbor. Accused Prafulla Chandra Kolita is known to me being resident under my area. This is Putuli Kolita was his wife and known to me. On 13/3/16 at night hour, one Deepak Bora, neighbor of Prafulla Kolita, has informed me that quarrel is going on the residence of Prafulla Chandra Kolita and wife of Prafulla was lying on road. On this, I went to the house of the accused and saw that Putuli Kolita was lying on the roadside in front of the house of the accused with injuries at neck, face, back of chest and leg. In the meantime, somebody has informed the matter to police, and just after my arrival, police arrived here. Putuli Kolita was not in a position to talk. So according to him, who met her immediately, she was not in a position to talk. But PW1 stated that in his evidence that she uttered name of the accused, although not in the FIR lodge. Putuli Kolita was not in a position to talk. Immediately with the help of police and by calling 108 ambulance service, Putuli Kolita was brought to Joysagar Civil Hospital. I also accompanied her. By that time, her son Manas arrived at hospital. At about 7-8 a.m., Putuli Kolita expired at hospital. Police came to hospital and conducted inquest on the dead body. So, exhibit 2 is inquest report and 2 is my signature. Profulla Kolita and his wife Putuli Kolita resides in their house. Their children used to reside at separate residence. Putuli Kolita has 2 wives. Other wife reside at Titapur with her children. Cross. I have not seen the incident of assault. Due to family dispute, the 2 wives lives at different places. Wife residing at Titapur is the first wife. Putuli was the second wife. One of the 2 sons through Putuli resided Delhi and another Manav Kolita resided Sibsagar. Profulla Kolita has some family quarrel with Manav Kolita, and I have heard that Profulla has filed a case on this matter. Since then, Manav Kolita used to reside separately. Due to their family quarrel, villagers normally did not maintain visiting terms with them. It is not a fact that while giving statement to police, I have not stated that I have seen injuries at neck, face, back of chest and leg. It is not a fact that the deceased did not get any such injury as stated by me. PW4 is the son-in-law of the son-in-law both the accused and deceased. Accused Profulla Kolita is known to me being my father-in-law. Deceased Putuli Kolita was my mother-in-law. On 13/3/16, while I was at my residence, police had informed me that my mother-in-law was at Joysagar Civil Hospital as she was assaulted by her husband. I arrived at the hospital at about 8 a.m. and found that she was alive. After 10-20 minutes, Putuli Kolita expired at the hospital. Cross. My residence is at a distance of about 3 kilometers from the residence of my mother-in-law. Due to family disputes, the 2 wives of Profulla Kolita lives at different places. Manas Kolita used to live with Profulla Kolita and Putuli in their house. I cannot say whether Manas was there on the date of incident. I have heard that there was quarrel between Manas and his father Profulla Kolita. On land dispute matter, the quarrel took place. Presently, Manas Kolita used to reside at Sibsagar. I have no personal knowledge as to how Putuli Kolita got the injuries, but I know that Putuli Kolita was made and in character and was mentally disturbed. Then PW5 is the Rajan Kolita. According to whom PW1 he came to know from Rajan Kolita. Accused Profulla Kolita is known to me being my uncle. This is Putuli Kolita was my aunt. My residence is in the backside of the accused house. On 13/3/16, on hearing hue and cry at the residence of accused Profulla at about 4:30 a.m., I went there and I saw that Putuli Kolita was lying on the courtyard of the house of the accused with injuries at neck and leg. I have informed the son of the accused who used to reside at Joysagar. Somebody of village informed 108 ambulance. Putuli Kolita died at Joysagar Civil Hospital. Profulla Kolita and his wife Putuli Kolita resides in their house. After the incident, Profulla was not found in his house. I have heard that he has surrendered before police. Cross. I have not seen the incident of assault. I cannot say who made the cry. Due to family dispute, the 2 wives of Profulla Kolita lives at different places. I have no knowledge of reason of dispute as I did not maintain any relation with the accused family. It is not a fact that due to previous sore relation, I deposed falsely against the accused. PW6. Accused Profulla Kolita is my uncle in relation. Deceased Putuli Kolita was my auntie and wife of Profulla Kolita. On returning home from Coach Bihar, I heard from his hearsay. I heard from other that Profulla Kolita was killed his wife Putuli. In this respect, on 13/3/16, police seized 1 dhow and 1 chadar from the place of occurrence. On the date of incident, I was at Coach Bihar. I have not seen the incident of assault. I cannot say whether the incident took place. It is not a fact that while giving statement to police, I have stated that the incident took place inside the house. I arrived on the next day of incident of assault and signed in the seizure list. So at the time of seizure, he was not there, Lord. because as per him, seizure was on 13/3/16. I arrive on the next day of incident of assault and sign in the seizure list. On the date of incident, I was not at my residence. Police recovered the material exhibit from roadside ditch. I cannot say to whom this dove belongs or how it was lying in the ditch. The ditch was on the outside the compound of the accused. I have not seen seizure of any dove from inside the house of the accused. So this is regarding the dove only logic. Then PW7. Accused Prafulla Kalita is known to me as co-villager. Deceased Putuli Kalita was the wife of Prafulla Kalita. In their residence, accused used to reside with his wife Putuli Kalita. On 13/3/16, while I went to residence of late Jibon Choikia from so-and-so, I came to know that on the previous night at about 10:11 p.m., accused Prafulla Kalita killed his wife Putuli and that she was taken to Joysagar Hospital. While I was at the residence of Bhupen Soikia to take stock of the incident of death of Putuli, Amguri police arrived at the residence of accused. Police seized one chadar from the roadside dish in front of house of the accused. I have not seen seizure of any dove, but heard that one dove was recovered from said ditch. Cross. The incident of assault took place on previous night. I cannot say the date of incident. I have heard that administration has recovered the dove. I have signed in the seizure list at the place of occurrence. So 6 is regarding that dove and 7 is regarding that sadr. PW8, Deepak Bora. Accused Prafulla Kalita is known to me as co-villager. Deceased Putuli Kalita was the wife of Prafulla Kalita. On the next day or morning of the incident, neighboring people, one Mr. Borua have informed me that accused Prafulla Kalita has killed his wife Putuli and asked me to go to one police personnel of our village. After arrival of Gaonpura, I went to the residence of Prafulla Kalita to take stock of the incident of death of Putuli. I saw that Putuli Kalita was lying in the courtyard with multiple injuries. Amguri police arrived at the residence of accused. Police sent me and Gaonpura to Sen Soikia with the injured to Joysagar Hospital. Putuli was admitted to hospital. After some time, son of accused Manas arrived there. Putuli died at hospital during treatment. Cross. I have not seen the incident of assault by accused. I cannot say the name of Mr. Borua. I cannot say whether Borua is his name or title. Villagers do not maintain any relation with accused for his ill temperament. It is not a fact that due to ill feeling for the accused, I deposed falsely. PW9 is the IO. On 13/3/16 at 4:50 a.m., while I posted as attached officer at Amguri police station, on that day, when the then duty officer has received one information over phone from Jintu Neo, constable of Assam police, regarding murder of wife of Prafulla Kalita by said Prafulla Kalita with a dove at his residence. On getting this information, same was entered so and so and entrusted me to proceed at the place of occurrence and to investigate the matter. Accordingly, at 5:30 a.m., I went to the place of occurrence, that is residence of accused Prafulla Kalita at Khamdoi Kakoti Gaon, and saw that Putuli Kalita was lying inside her house in injured condition. By that time, Gaonpura and others came there. I also saw that in the meantime, while 108 ambulance service arrived there, I saw several cut injury marks on the person of Putuli Kalita. Considering seriousness of the health condition, injured was sent to Sibsagar Civil Hospital, and few other, which Gaonpura and few other villagers. At about 7:30 p.m., so-and-so informed over phone that the injured Putuli expired at hospital. On this information, I came to Civil Hospital Joysagar at 8:40 p.m. Possibly this is A and Lordship. I have conducted inquest on the dead body of Putuli Kalita. So-and-so inquest report. Requisition was issued for postmortem. I have also recorded a statement of to here, Lordship, in the second copy, in one of the paper book, Lordship, 21A is there, but in another paper book, Lordship, 21A is not there.
Okay.
So at that time, I had pointed that it was not there, so they have Xerox only one page,
Okay.
21A. It is in the
This page is not here. Please give it. Yes, yes. You have to give copies. You have to make copies. Yes.
in fact, in my copy also it is not there, but I have photocopied it. Lordship. I have also recorded a statement of two witnesses at hospital. আছে না? ওই মহিলা। Logic got it. Witnesses at hospital. After handing over the dead body, I went back to Amburi police station on 13/3/16 at about 11 a.m. That day, Amburi,
I can make this faster.
the then OC, Amburi police station has received one written FIR from so and so, son of the accused, and registered Amburi so and so. During investigation, I have recorded statement of witness. At about 11:10, accused Profullo Kolita has surrendered at Amburi police station and confessed his guilt of assault to his wife. He was arrested. I have recorded his statement under section 161 CRPC. In his statement, accused Profullo Kolita has stated that due to frequent quarrel by his wife on 13/3/16 at about 4 a.m., he has cut his wife with a dowel, and thereafter the dowel was thrown in the nearby ditch having water. After recording statement, accused again went to place of occurrence and recovered one dowel as stated by the accused, one cotton sweater, and seized the same by so and so. I have drawn a sketch map of the place of occurrence. Exhibit 5 is the sketch map. I have also recorded statement of other witness. During investigation, I have collected the postmortem report. On completion of investigation, I submitted charge sheet against the accused under section 302 IPC. Cross. I have done some part of investigation on the basis of Amburi police station GD entry number so and so. Copy of above GD entry so and so. I have not referred the existence of above GD entry in the charge sheet. I have examined informant after receipt of FIR. There was no mention of the name of accused as murderer of his mother. Murderer of is not murder his wife. In his statement also, he did not implicate the accused as assailant of his mother. Zintu Neok, on whose information the GD entry was made, was not examined by me as witness in this case. It is not a fact that no information was received from Zintu Neok and Amburi police station was concocted one and made after completion of the investigation. It is not a fact that accused did not confess his guilt before me. I have not sent the accused to court for recording his statement in court. I cannot say as to how the seized sadar was related with this case. I have not verified as to whom the sadar belonged. In the chisel list, there was no mention that seized article were recovered as informed by accused. So this is lordship important as informed. This is not mentioned that seized article were recovered as informed by accused. So rather there is mentioned that same were recovered on shown by the witnesses. In the exhibit 4, place of seizure was shown as place of accused. There was no mention that seizure article were recovered from this. It is not a fact that without properly investigating the case, I have submitted charge sheet against the accused. So PW9 was re-examined as re-examination in the next phase. I have already deposed in this case on the last day. Today, as directed by the court, I have appeared with GD entry book containing so and so. Exhibit so and so. This is information was received over phone from Zintu Neok, Constable of Assam Police, regarding murder of wife of Profullo Kolita by Said Profullo Kolita of so and so with a dowel at his residence and fled away. GD entry also contains that after making the entry entrusted to me to proceed to the place of occurrence and to investigate the matter. Cross. In the FIR, there was no mention that the accused assaulted the deceased with a dowel. Zintu Neok was also not examined. Then there is one, Zintu Neok was examined as a CW. Next. Accused Profullo Chandra Kolita is known to me as a co-villager and neighbor. Mrs. Putuli Kolita was the wife of Profullo Kolita. On 13/3/16 at late night hour, while I was sleeping at my residence, on hearing some hue and cry, some village boy came to my house and informed me that accused Profullo Kolita has cut his wife. On this, I sent them to inform the matter to Gaubura Susen Soikia. After some time, Susen Soikia came to my residence. On this, I had informed the matter to Amburi police station, so SI Gangadhar Lahon, and told that Profullo Kolita of our village has cut his wife Putuli Kolita. I have also went to the house of accused and saw Putuli Kolita was lying with bleeding injuries. As she was alive, I have called 108 ambulance. By that time, SI Gangadhar Lahana Manguri police station arrived. Putuli Kolita was sent to Joysagar hospital by 108 ambulance. Later on, I have heard that Putuli Kolita died on same day. This is crossed by defense. I have not seen the incident of assault by accused. Rajen Kolita and Povitra Kolita of our village initially informed me about the incident. Thereafter, Gaubura came to my house and informed the matter. On getting this information, I pass over the information to so-and-so. I have no personal knowledge about the incident. During investigation, IO did not record my statement. So this is the evidence. 313 statement was there, Lordship, and his case is of total denial, Lordship, and in page number 28, in reply to question number 23, he has stated that he went PW5, in reply to question of PW5, PW5 also deposed that after the incident you were not found in your house and he heard that he has surrendered before police. What did you say? So in his reply is that he went to the police station of her giving information regarding the incident. And another one is question number 29, the same page. PW8 also deposed that after arrival of Gaungura, he went to your residence and saw that Putuli was lying in the courtyard with multiple injuries. What is your say? It is false. Putuli was lying on the roadside ditch. So here, one or two witnesses say that it is courtyard, but others are saying that it is outside his residence. Question number 35 also he stated that when he reached police station, he came to know that already his son has lost the FIR and he refused to receive his FIR, although he went there to lodge the FIR. And confession regarding he had denied lordship. And in page number 31, in reply to question number 48, he had stated that on whether you have anything more to say on the case and the evidence. On 12/3/16 and 13/3/16, Bhagavat Path was going on our village. On 13/3/16 at about 5 a.m. while I returned home, I saw that my wife Putuli was lying on the roadside in injured condition. She waved her hands to me. I went to the residence of Koli Kolita and informed him about the incident. She informed me that I should arrange a vehicle for taking her to medical and also to inform police. In search of vehicle, I went to main road, and on getting one tempo, I went to Ampuri police station, which is about 15 kilometers from my residence. At about 8 a.m., I arrived at Ampuri police station to file an FIR, but police asked me seat as my son has already filed FIR and police has already went to my house. Thereafter, I was taken for medical examination and arrested me in this case. I'm innocent. I had frequent quarrel with my son Manas. He asked me to leave my house. He did not take care of me. He demands money from me. I have to file case against him. I have not killed my wife. Here, Lordship, now I want to read the scissor limit, page number 66. Here they had mentioned only about the Dao, not about the chadar. That is the only, no, sorry, Lordship. The next page, this is here, Lordship. One cloth chadar, which is weight. So one witness for the Dao and one witness for the chadar. I, the undersigned, do hereby seize the below noted article as found at the place of occurrence, which is shown by the witnesses in connection with the case in presence of below signed witnesses. So he, in his evidence, stated that place of occurrence is the ditch. Ditch is written as place of occurrence in the scissor. And the ditch is outside the house of the. This is possibly like a drain or something, possibly like that. this is the evidence, Lordship. And on the basis of that, Lordship, he was convicted under section 302. He was in jail for last, from the date of incident. And there was no visiting terms with the villagers and no good relation with his son also. And Dinda Hajjahar also, although they knew, if we go by their prosecutor's story, at that time of lodging the FIR, they were aware that he is the accused person, but no name was there, and there is discrepancies regarding the injuries also. And place of occurrence, then where is she was lying, if she was in a position to talk in the hospital and she was alive at the time, and why she have not stated anything regarding the accused person about in front of any of the villagers. And the evidence that although there was no relation with the accused family, why in the midnight or sometime the other person will came to see what had happened. And if we see, some has stated that it was at about 10, 11 or something like that. But apart from that, someone has informed his son, no one had even tried to take her to hospital. And his evidence that he was not there, that is, no one has stated that, but no one had ever stated that it was there, nothing was there, no question on that. Then re-examination or something could have been done regarding the prosecution witness that to so that the plea of alibi is not correct, Lordship. If she was alive, so even her statement would have been recorded if she has uttered the words in front of her son, if PW1, then would have been taken note of that by other evidence, police or some other personnel also, Lordship. Caesar is not that he leading to discovery. It is not shown by the accused. From this paperwork, I have not seen anything to state that the accused has shown this. Neither the Caesar list nor the Caesar witnesses have stated that. Even one Caesar witness has stated that he came later on. The dao was recovered on the earlier date. The other person was there, but that is belong to the lady or deceased. That is also not there. The dao was also not perhaps sent for whether there is any bleeding or something like that. Those were also not there, although it may not be necessary if it is corroborated by other evidences. But there is so many contradictions, and there is one main ground is that, Lordship, the villagers have a very bad relation with him for whatever reason. Even the accused had a bad relation with his son. That is why possibly he is still, from the date of incident, no one had ever tried to acquit him, or he is still inside jail, Lordship. And two wives, that is also a reason. His family dispute is also there, Lordship. That is.
But, yes. Dying declaration is there. Dying declaration can be the sole basis of conviction. But of course, one of the witness had stated that she was not in a position to speak. But then Lordship knows that one can speak, even 99% burn and so many injuries, one can still speak. Someone saying
The,
that
the
she
police would
was,
have recorded that demeanor.
Ah.
But how was it communicated? If one
Yes.
witness says she can't speak, you have to
Anyway,
demonstrate.
that is an oral dying declaration, and we need some corroboration to that. Even if we consider the son's statement, other things that there was a fight, PW3 had stated that neighbor informed there was a fight at the night between husband and wife. And her body was lying with injuries in the ditch. The PW 3 and 5 both stated about.
But then, then it goes against your sketch map.
That's
See the sketch map,
lordship.
page 68.
Paper book 68. No, sketch map.
The place of recovery of dead body is not mentioned.
Acha. Oh no, that she was brought inside home. I think the police personnel said that she was lying on the bed inside the home. So by that time, perhaps the neighbors had brought her inside. No, what happened there? Anisa कौन है? Nobody had said that she was brought, but the police personnel had found the body inside the house.
Not body, if she was taken to the hospital,
Oh, oh.
it cannot be body.
Not body, yes. Her inside the house. No, police no. There's somebody else.
She was alive
Uh,
while taken to the hospital.
yes.
That is also contradicting logic. That she was actually alive or not.
তো কোনে কৈছিলে at home? At home কোনে কৈছিলে? I found it somewhere. At home, she was lying on the bed. I went to the saw, Putuli was lying on the roadside in front of the house. Okay. Then, number 4.
Because this PW8 says lying in the courtyard.
But I found someone saying at home. There was somebody lying on the courtyard. PW5 also courtyard. 6, it's not the. I killed his wife.
PW9.
PW9.
I love.
Lordship will see IO's evidence. Lying inside the house in injured condition. I went to the house of the occurrence residence. That is residence of Prafulla Kolita at so-and-so and saw that Putuli was lying inside her house. So then the sketch map was made and she was seen inside the house. By that time, the Gambura and others had come. I also saw in the meantime, ambulance had come.
The 313,
313.
the accused says that his body was lying in the ditch.
Did her injured wife. He was in some religious function. When he came back, he saw the body lying in the ditch. This is what his explanation is. In the GD entry, the name of the assailant is there. FIR, perhaps the son, did not like to put the name of his father. Two witnesses have stated about the quarrel. Husband and wife had some quarrel. He had 2 wives and all. He doesn't have good relation with his son also. Son from this wife.
What to say about the recovery of Dow? It was never sent for forensic, therefore, this is the Dow used for
Those are
crime.
not done. Dow was found in the place of occurrence. It was picked up.
No. If it is in the house, it was thrown outside. If the place of incident is house, then the Dow was thrown outside. Not at the place of occurrence, it's near the place of occurrence.
Yes, place of occurrence, whether it is inside the house or in the courtyard, there was a fight. She must have come out and then there was a assault made. And Dow was left there. Throwing the Dow out of the house, it's again a presumption.
Away from the beach.
Mm. See, this is the place. See.
Incident occurred with the courtyard.
See where to throw it there.
In fact, my humble submission is dying
And the
declaration
drawing
with the
indicates-
corroboration.
indicates
Otherwise, there are no
somewhere
materials.
in-
Corroboration is that there was a fight at night and they were the only person staying.
This now indicates that it happened inside.
I'm not the world. There.
Lordship, মানে তো তেনেকে
বেলেগে কৈছে।
4:30 AM. 4:30. Can cry to মানুহ আহি দেখিও হ'ব পাৰে সেই বুলি কোৱা
Three, that's it, 3W3, that heard. W3 to শুনিছে at night hours.
দীপক বৰা inform him
Oh,
one is there দীপক বৰা is PW8
Deepak Bora inform কৰিছে.
totally কোনো নামেই পোৱা নাই he came to know Mr. Borua he even has no knowledge about his আমি নাম না তুমি চাব চাবি I could not know whether Borua is his name or not no evidence of quarrel also
Quarrel part is again not believable because Deepak Bora, PW3 said that one Deepak Bora informed that there was quarrel at night. But Deepak Bora is examined, he did not say anything.
PW8
And
The person who gave the GD entry, he was not examined.
not examined. And PW5 said about hue and cry, but at 4:30 AM in the morning. And quarrel part is said at night. So corroboration to oral dying declaration is again lacking.
One of the factors is that the accused in his defense says that at that time he had gone for a religious function, but that was not again proved.
That was not. Nobody had said about any religious function on the previous night.
Because if that falls under 106, it will be the onus of the appellant to show something more.
my humble submission is their lordship because other witnesses and the age group of the appellant is different. Maybe possibly that may be a reason because he is in his mid-70s and they are of the younger generation. So possibly prosecution could have even cross-examined by another person also that whether actually he is lying or not. That there is a age gap and a person of 70 plus, he may go to watching that it may not be such a large extent because and they who are the younger generation, they may not be.
Pardon me, I did not
Lordship,
catch you.
a person of around 70 plus, he may have attended a Bhagavad Gita. And it's not that it's such a larger extent. It may be in someone's house or something like that. And the other accused person who is possibly, that is what generally happens that Bhagavad Gita and such types of religious function generally persons of some age may have
No,
attended.
but somebody must give evidence of that religious function.
That possibly cannot be taken on to against the accused only
Because
when
then the
others-
witnesses could have been asked that question that on that day, whether in the house of so and so, Gita Path was going on. And he would have said that, you see, when you are taking a plea of alibi, the accused could have said that I was in their house, so and so person saw me.
Because he said 2 dates. It is not that he had said it one date only. He had said on 12/3/16 and 13/3/16. Bhagavat Path was going on in our village. So village means in which house or something, it may be in a remote or this.
No, but
distance
he will
from
not be the sole person in the Bhagavad Path. Somebody would have seen him. This is a plea of alibi, which there will be people who will
maybe
confirm.
Uh, whether
Because today, you see, today if I go to say a temple, let us say Sukreshwar, if I go there, people may not know me. But in a village, when you go to a function, everybody knows everyone. It's not that somebody may miss me. But yes, in Guwahati, if I go to a temple, nobody will recognize me.
Incorrect statement of the accused will be only a link in the circumstance. Now,
and
here,
if-
even if it is incorrect.
they-
But here circumstances are what? Here there was a fight. Morning, somebody informed the son. And then son went to the hospital and then mother had given a dying declaration. And the dove was recovered and it's a homicidal death. These are the circumstances.
in trial stage also he is, state defense counsel has argued on his behalf. Possibly he had not engaged any of his personal lawyer. That is why he is still in jail also. That
27 recovery actually goes, that is a wrong application by the learned trial court.
Don't you think? You'll be giving them benefit of doubt. The, the place of seizure, the place of dead body, everything.
It's not matching. Dying declaration is also, person has said, not in a position to speak, and she had died within few hours. That oral dying declaration is difficult to believe. Otherwise,
No, but
suppose,
the, even the son did not take care to take the mother
Huh.
to the hospital.
he came directly to the hospital, he was in Sibsagar, so he did not come to the house.
They, but to attend the, just see that part.
Even for the ambulance.
PW3 also says by calling ambulance. Who called ambulance is not,
Son, he said that he had called the ambulance, but
son is PW1.
one. Somebody had informed the matter to the police and just after.
No, no, at my request, 108 was called. He did not call it.
Yes, at my
At
request,
my
yes.
request. Because she was there for 2 hours. In the hospital, nobody noticed. Nobody took care to record a statement. Or so nurse, doctors, nobody came and said that she said that.
Nobody. And there is already a bad relation between the father and the son. Perhaps he had just said this.
This Rajan Kavita is also not examined.
He was examined.
Is examined. Where is his evidence?
Five. Was it
Rajan PW5.
His evidence is that he heard the hearing human cry at the residence of at about 4:30 there, and I saw Putuli Kolita was lying on the floor there. This hue and cry is not that there was any quarrel. This hue and cry is that person already gathered there, not possible.
Person.
Was
So he went cry in the morning after the incident.
it's not that he heard any quarrel.
Putuli Kolita lying on the courtyard.
Possibly evidence was brought, but that is also not clear. I cannot say who made that cry.
I mean,
Oh,
PW3 says roadside.
regarding Caesar Lordship, one thing, Lordship may kindly come to page 69. This is the sketch map. Here, page 69.
Yes.
Here 3C. Lordship may kindly see the place where the Dao, Chadar, and the Kukri. But this Kukri is not in the Caesar list. But sketch map say that along with the Dao and Chadar, Kukri was also there. So why in the Caesar? This Kukri was missing, Lordship. Yes, ma'am. Teaser is also not very clear. Two person for two seasons. And that was also not possible in the same time. From the same ditch, why this kukri was not made a part of the season. And maybe that's
এখন চাদৰ এখন ফটো নহয় মইতো এতিয়া অৰিজিনেল
দেখিছে।
সুধিও আছে বোলে ঘৰত।
ইয়াত দেখিছে এইখন কুকুৰীটো 9 পেজত।
ইণ্ডিকেটিং ন
Place where the dhow, chadar and the kukri are found.
এখন দাখন চাদৰ এখন পুখুৰী পুখুৰী নি এখন পোৱা যায় দাখন চাদৰ পুখুৰীহে
পুখুৰী পোৱা ঠাই
যায় নে ঠাই
যায়।
Not kukuri, I think it's pukuri. Pond. Pukuri is translated as kukuri. In the Assamese version, it seems like pukuri.
But the Pukri you don't write in the,
Sketch map.
write in the sketch map. It's something you don't.
No, what they said, দাখন চাদৰ এখন পুখুৰীত পোৱা যায়। পুখুৰী পোৱা যায়।
The ditch is not shown as 3C. 3C. C. Bamboo, only bamboo is shown.
পুখুৰীও হ'ব পাৰে খ and প
Pukri. Pukri.
like পুখুৰী here.
Translation it is
And there's no kukuri in this Caesar. There's no pukuri, but I think the ditch was termed as pukuri.
doctor evidence that may be caused by sharp object. Paralysis. Kukri is specifically mentioned in inverted commas.
পুখুৰী লাগিছে accused of যে তাত ঠাইটোত পোৱা নাছিলে এইটো ক'ত আছে মানুহবোৰ আহোঁতে তাক আছে accused is he was not at home.
He did it too.
This is I heard. Was not found. After the incident, was not in his house. I'm not the problem.
Just pass me the LCR.
The person who gave the information, the GD entry, he is examined as court witness. As court witness. Definitely.
Not Khupri.
Khupri. P.
P for boys, apparent.
Maybe because in the translated version, it is written as Khupri and inverted commas, it is.
But the sentence is not correct. দাখন সাদর এখন পুকুরি পোয়া যায়।
Correct. No vowels, nothing.
আৰু এখন কৰি পোৱা যায়, the door is missing.
It's your fault. मोटा आगे secure.
Oh, wait, wait.
मोटा हो गया. No, it's okay. This is police examination page 21A. This is corroborated also from the evidence of the IO,
Which one, Lordship?
the Pukri, that you will find 21A.
There was
So-
found in the nearby ditch having water.
Having water. Because if that be so at 4 AM, 4:30 quarrel, the accused will have to give some explanation.
No, there's given explanation, but it is incorrect. It's not a case of no explanation. He has given an explanation, but it is incorrect. He said, I was there 5 AM, I came to home and I saw.
The evidence is that he was not at home. The witnesses have not found him.
So,
PW5 said he was not at home.
And if Lordship goes to the CW1 Jintu now, Lordship, page number
PW,
CW1 Jintu now, who had the 24, page number 24. Regarding the GDNP, etc. On 13/3/16 at late night hour, while I was sleeping at my residence, on hearing some hue and cry, some village boy came to my house and informed me that accused Prafulla Kolita has cut his wife. On this, I sent them to inform the matter to Gaubura Susen Soikia. After some time, Susen Soikia came to my residence. On this, I had informed the matter to Anguri so and told that Prafulla Kolita of our village has cut his wife Putuli Kolita. I have also went to the house of accused and saw Putuli Kolita was dying with bleeding injuries. Yes, she was alive. I have called 108 ambulance. By that time, so-and-so has arrived. So then cross, he has stated that Rajan Kolita and Povitra Kolita of our village initially informed me about the incident. Thereafter, Gambura came to my house and informed the matter. On getting this information, I pass over the information to so-and-so. This, but Rajan Kolita, this PW5. He has not stated that he went to Jintu Neam's house. My residence is in the backside of accused. On 13/3/16, on hearing hue and cry at the residence of accused Prafulla at about 4:30 AM. So he is saying that at about 4:30 AM, and as per Jintu, it was late night hours. So 4:30 possibly late night hours lodging. 4:30 is almost dawn lodging.
Dawn on that day was 5:14 AM.
Already night.
But yes, 4:30 would be, some daylight would be there. She's right.
On hearing hue and cry at the residence of accused Prafulli at about 4:30 am, I went there. I saw that Prafulli was lying. He had nowhere stated that he went to Jintu. He along with one Pavitra, and Pavitra is possibly not examined. And Jintu was also not not examined by the police immediately, Lordship. That he's informed during investigation of the case, IO did not record my statement. He was only a court witness. Rajan Kolita nowhere stated that he went to intimate Jintu, and now Susen Kolita is also there. Susen Kolita is PW3, possibly PW. Yes, PW3 is Susen Soitia. His question is that on 13/3/16, late night hours, Deepak Bora, neighbor of Prafulla, has informed me that quarrel is going on in the residence of so-and-so. I went to the house of the accused and saw that Putuli was lying on the roadside in front of the house of accused with injuries at so-and-so. In the meantime, somebody has informed the matter to police. So if we'll go by Jintu's evidence, the Rajan and Pavitra went there and Susen subsequently, who is the Gaubura, but they have not stated that they went to intimate Jintu. So somebody had informed the matter to police. He accompanied the deceased to the hospital, who was at that time alive, Lord. And as she was alive, she had not uttered about the accused name in front of any of the witnesses. And Deepak Bora, and Deepak Bora's evidence is nothing logic. He even not, his evidence is that someone Borua had informed him about the incident. He even don't know whether Borua is his name or title. So it is also not believable in a village where he is not aware about the person. And all our knows about the fact from Deepak Bora, but Deepak Bora's evidence is nothing from whom he had actually came to know. Rajan know from Deepak Bora. Rajan informed Susen, but Deepak Bora had stated that one Mr. Borua have informed me that accused Prafulla Kolita had killed his wife Putuli and asked me to go to one police personnel of our village. So as per this, he went to meet one police personnel, Jintu. And what Jintu did, he again slept and told that you inform Gaupura, and then only he intimated the police. And Gaupura's evidence is that somebody already had informed, and police arrived immediately when he reached. So time is also a factor here regarding actually whether it is morning or in the night hours, early night hours or in the morning hours. And
No, times are given, so that there's no problem with that. If I wake up at 10 o'clock, is morning, is 7 o'clock would be night. But the
right.
450 GT is already recorded.
And had tried to take her to the hospital. While she was possibly in a stable state.
Because at 5 PM as per his diary, he's already left.
One was also. There is some discrepancy regarding injuries also. That is leg is not at all in the medical evidence.
Case diary, sorry, the case records. Just check up the entries for that recovery in the copy of the case diary. At what time it is recorded?
This is not actually a 27 recovery that was wrongly held by the trial court. Not a 27 recovery, it's a wrongly held by the trial court. There is nothing on record that he led to the recovery.
So
Witnesses have shown.
then he gets a benefit of doubt.
Witnesses have shown, police said.
The
Also
recovery,
there,
the recovery statement is not there, then
27 recovery is not there.
He has not led the police to the place also. Just discovered by.
Just check up in the,
Notice.
noting in the case diary. File 4. Third.
Certain circumstances, I just wanted to point out. If it at all is sufficient. One is that quarrel at night, that was heard. Because Deepak said that there was quarrel at night. PW3. No, Deepak said to him.
No, quarrel is not said.
Occupancy PW3. At night hours on Deepak Bora informed me that quarrel is going on in the residence of Prafulla and wife of Prafulla was lying on road.
But Deepak.
Quarrel is going on in the residence
Okay, see Deepak Bora,
at night hours.
PW8.
See-
Deepak Bora did not say anything.
it goes.
Hue and cry in the morning, 4:30. People must have gathered by then. PW5.
But nobody identifies that he was there, they were there, this. That is not there.
PW5, he said that on hearing hue and cry at 4:30. I went there and I saw Putuli was lying. So night there was a quarrel, 4:30 hue and cry, he went. Witnesses went, injured body in the courtyard of the accused. Then accused is missing. PW5 said that accused was not found in the house.
That explanation given, Lordship, he went to the police station.
That also is not there. Evidence is not there. Statement made itself is not sufficient.
That is 313, that is different.
This exhibit 7 is his statement. Which page is it? Exhibit 7?
75.
70.
কথা নাই আদৰ এখন কথা হলো
Sharma is amicus curiae and Ms. S.H. Baral and APP for the state. Yes.
Said Bora.
Oh, sorry, Ms. S. Jahan, APP for the state. by filing this appeal from jail, the appellant has assailed the jail, which is presented to the Learned Legal Aid Council. The appellant has assailed the judgment and sentence dated 16/11/2017, passed by the Learned Sessions Judge Shiv Sagar in Sessions Case number 169 within bracket S-S bracket closed of 2015. 16, arising out of GR case number 358 of 2016 under section 302 IPC. Next paragraph. At about 11 a.m. on 13/3/2016, the informant Manas Kalita, MANASH Kalita, the son of the appellant and the deceased, had lodged an FIR with the officer in charge, Amguri PS, stating that his mother was physically assaulted and she had succumbed to her injuries. Full stop. It may be mentioned that prior to the lodging of the FIR, on the basis of information received from one Jintu, JINTU, Nyog, Amburi PS GDE number 336 dated 13/3/2016 was registered at about 4:50 a.m. with allegations that the appellant had caused grievous injury to his wife, within bracket the deceased, by dealing, DEALING, dealing thou blows inside the house. So the said information was registered as GDE number. The number is already given. So first of all, according to the deceased, and then in injured condition, was sent to what is the name of the hospital? Joysagar Hospital, JOYSAGR Hospital, Full stop. Upon death of the deceased, comma, inquest was conducted over the dead body and postmortem examination of the dead body was also performed. Full stop. Subsequently, Amguri PS case number 31 of 2016 was registered on the basis of FIR within bracket Exhibit 1, comma, lodged by the by Manas Karita within bracket PW1. Full stop. It is projected that the apparent Prafulla Chandra Kalita had surrendered at Amguri PS and had confessed his guilt. Accordingly, he was arrested and as per the statement given by the accused before the police, comma, a dao, which is said to be the weapon of offense, was recovered and seized along with one chadar. On completion of investigation, comma, charge sheet number 44/2016 was submitted and dated 30/6/2016 was submitted. Full stop. Next by the learned additional chief judicial magistrate, comma, Sivsagar, after complying with the provisions of section 207 CRPC, had committed the case for trial before the Court of Sessions. The appellant was on jail, was in jail all throughout. Next para. By order dated 31/8/2016, comma, charges under section 1302 IPC was framed, and on explanation of such charges, comma, the appellant pleaded not guilty. Full stop. Next, during trial, comma, the prosecution had examined 9 witnesses, namely page 54, and the following were exhibited. I have given the exhibit number and the PWs who have sponsored. The, it appears that the IO had not exhibited the GD entry. And therefore he was re-examined. And thereafter, by order of the court, comma, one Jintu Niog, GINTU was examined by the court as CW1, as his information led to the registration of Amguri PS GD entry number 336 dated 13/3/2016. Next paragraph. The learned sessions judge had examined the appellant under section 313 CRPC and incriminating circumstances appearing against the appellant was put before him. First of the appellant took a plea of denial and took a statement and gave a statement in defense, comma, stating that on 12/3/2016 and 13/3/2016, this quoted from page 31. There's a flag. Question 48. Full stop. However, comma, no defense exhibit, the witness was examined. Next, it may be mentioned that in the judgment, the learned sessions court has recorded that the appellant was in jail since 13/3/2016 and nobody had come forward to take bail for him, and therefore at his request the appellant was provided with the service of State Defense Counsel. Next paragraph. The Ignorant Trial Court had formulated two following points for determination. This is at page 30, 34, or 35. Next paragraph. We briefly narrate the evidence of the witnesses. First off, Manas Kalita, within bracket PW1, who is the son of the deceased and the appellant, has stated in his examination in chief that on 13/3/2016, while he was residing separately at Joysagar, at about 4 a.m., Rajan Kalita, his cousin, had informed him over phone that the appellant had killed his mother, within bracket Putuli, Putuli, and requested him to come early. Just stop. He deposed that at his request, an ambulance was called and his mother was brought to Joysagar Civil Hospital, and he had also reached the hospital. He claims to have seen his mother in the emergency ward, and at that time she was alive. And he saw some injury marks on the head, finger, below the knee. And on his inquiry, his mother, then alive, had stated that the appellant has assaulted her. And after about 2 hours, she had expired. And thereafter, he has lodged an FIR within bracket Exhibit 1. Thereafter, the police came to the hospital and the inquest was conducted on the dead body. And he had exhibited the inquest report within bracket Exhibit 2 and his signature thereon. In his cross-examination, PW1 had admitted that in the FIR lodged after the death of his mother, he did not mention that the mother had accused the appellant of assaulting her. And it was also admitted that in his statement before the police, he did not state that about 4 p.m. We'll take a break and come back. He also said that in the FIR, he had only mentioned that his mother died in hospital due to assault on her. And he has also admitted that while giving statement to the police, he had not stated that at 4 a.m., that on the date of incident, at about 4 a.m., his cousin Rajan Kalita had called him and told that his father had killed his mother and requested him to come early. However, he had admitted that since last 5 to 7 years, he was living separately from his parents. And during this period, he did not visit his parents. So he had denied that about 5 months back, he had visited his parents and physically assaulted them, for which his father had lodged an FIR at Amburi police station. So he had denied that out of previous grudge, he has falsely implicated the evidence. We'll take a break and come back.
I beg to mention, I didn't know leadership. I there for some time, but there are some personal difficulty.
Ask someone to be there. Because in the middle, I'm not passing any orders. Dr. Mrinmoy Borua, MRINNOY, MRINNOY, Mrinmoy Borua, BARUH, when conducted the postmortem examination was examined as PW2. Full stop. The injuries found by him on the dead body are as follows. Paper book, page 11 and 12. Full stop. In his opinion, the cause of death was due to hemorrhage and shock leading to syncope, SYNCOPE. Full stop. He had exhibited the postmortem examination report within packet exhibit 3 and his signature along with counter signature of the joint director, health services, Shiv Sagar. And he had also stated that the injury numbers Ms. Jan, what is this 1, 2, and 3? Page 13.
PM, doctors,
Yes. Page 13 of the paperwork. Injuries number 1, 2, and 3, and injuries on brain. Injuries 1, 2, and 3 is he referring to 2, 1, 2, 2, 2, 2, and 2, 3? T-page.
2, 1, 2, and 3 are cheek and temporal region and yes,
Okay, and where is this brain?
temporal region. Number 2. Incised wound over forehead extending to temporal region means this.
No, in page 13 he says 1, 2, and 3 and injuries on brain.
Yeah, no. Page 13. And injuries on brain. Yes, the injuries number 1, 2, 3 and injuries on brain are fatal in nature. No, 1, 2 and 3 and injuries on brain. That is lacerated wound over forehead. And brain also will find their cranium and brain. I think 3 will make it clear. Incised wound over forehead extending.
So in a postmortem report, there would be something of brain. Brain is a part of postmortem report. Let us check that. Page 62, brain and spinal cord healthy. Page 62.
Brain. Brain and spinal cord is healthy. But I think the injuries on the temporal regions were considered to be brain injuries. But because temporal is behind the head, this part. Otherwise, brain is said to be healthy. I will, let's see this external appearance. So, this cranium and spinal canal. There it is said incised wound over the temporal region, frontal region, occipital region. So all the three areas of the head. So how can the brain be healthy then? This question I asked myself. Lacerated wound on, lacerated is a cut wound. Lacerated wound over occipital, lacerated on frontal, incised wound on temporal, all the three parts. But brain and spinal cord healthy. Kind of like a brain injuries person that and injuries on brain are fatal in nature.
Okay, just say whatever is there. Injuries number 1, 2 within bracket, small 1, Roman 1, Roman 2 and Roman 3. And injuries on brain are fatal in nature. And such type of injuries may be caused by DAO within bracket material exhibit 1, M exhibit 1. Full stop. In his cross-examination, he had reiterated that the incised wound as found on the dead body may be caused by the DAO within bracket material exhibit 1 shown to me, and that the lacerated wound may be caused by sharp object if underlying surface is hard. Full stop. Sushen, S-U-C-H-E-N, Sushen Saikia, was examined as PW3, is the Gambura of the Oh, he did not say that he is Gambura. No, don't say that. What is exam PW3? Has stated that he knew the appellant being the resident under his area, and the deceased was his wife and known to her, was the appellant's wife and known to him. He has stated in his examination chief that on 13/3/2016, at night hours, one Deepak Bora, neighbor of Prafulla Kalisa, had informed him that a quarrel was going on in the residence of the appellant and his wife. What is the meaning of this statement? Kalita and wife of Prafulla was lying on road,
Lying on road perhaps.
lying on road, huh? There's a Prafulla, and then the wife of the appellant was lying on road. And accordingly, he went to the house of the appellant and saw the deceased covered. Saw the victim lying on the roadside in front of the house of the appellant with injuries at neck, face, back of chest, and leg. So stop. In the meanwhile, someone had informed the matter to the police, and just after his arrival, the police also arrived there. So stop. He had stated that the victim was not in a position to talk. And with the help of the police and by calling ambulance service, the victim was brought to Joysagar Civil Hospital, and he had also accompanied her. And by that time, his son, within bracket PW, so the son of the deceased, within bracket PW1, had arrived at the hospital, and at about 7-8 a.m., the victim had expired in the hospital. Thereafter, the police had come to hospital and conducted the inquest over the dead body. And he had exhibited the inquest report within bracket Exhibit 2 and his signature thereon. He has stated that the appellant and the deceased resided in their house, and the children used to reside at a separate residence. And that the appellant had 2 wives, and the other wife resided at Titabor, Titabor, with her children. In his cross-examination, he had stated that that he had not seen the incident of assault. And due to family dispute, the 2 wives live at different places. And the wife living at Titabor was the first wife, and the victim was the second wife. He had stated that the appellant had some family quarrel with his son within bracket PW1, and he had heard that appellant had filed a case in this matter. And since then, the PW1 was residing separately. He also stated that due to their family quarrel, the villagers normally did not maintain visiting relationship with them. Stop. He had also admitted that while giving statement to the police, he had not stated that he had seen the injuries referred earlier. Next paragraph. Jintu Gogoi, Jintu Gogoi, was exhibited, was examined as PW4. First up, he is the appellant was his father-in-law, and the deceased was his mother-in-law. First up, he is a hearsay witness who did not see the assault, and he was informed that that his mother-in-law was at Joysagar Civil Hospital on being assaulted by the appellant. He arrived at the hospital at about 8 a.m. and found her alive. And after 15-20 minutes, she had died in the hospital. He had also exhibited the inquest report within bracket Exhibit 2 and his signature thereon. In his cross-examination, he had stated that he had heard that there was a quarrel between the appellant and his son within bracket PW1 over a land dispute. And that Manas Karita within bracket PW1 resided at Sivsagar. And he had no knowledge of how the victim got injuries. First of all, he had stated that the deceased was mad, MAD, mad in character, and was mentally disturbed. That's why Rajan Kalita was examined as PW5. And the appellant was his uncle and the deceased was his aunt. And his residence was in the backside of the appellant. Full stop. On the date of occurrence, on hearing a hue and cry at the residence of the appellant, at about 4:30 a.m., he went there and saw the victim lying in the courtyard of the house of the appellant with injuries at neck and leg. First of, he informed the son of the appellant, who used to reside at Joysagar, that the victim had died at Joysagar Civil Hospital. He had stated that after the incident, the appellant was not found in his house. And he had heard that he had surrendered before the police. In his cross-examination, he had stated that he had not seen the incident and could not say who had made the cry. He had no knowledge about the dispute between the dispute in the family, as he did not maintain any relationship with the family of the appellant. However, he denied that due to previous sour relationship, he had falsely deposed against the appellant. Jadav Saikia, JADAV Saikia, was examined as PW6. He had also stated that the appellant is his uncle and the deceased was his aunt. He stated that on returning home from Kuch Bihar, he had heard from others that the appellant has killed the deceased. Stop. The police seized one dao on 13/3/2016. Dao and a chadar, CHADR chadar from the place of occurrence. He had on 13/3/2016, and he had exhibited the serial list within bracket Exhibit 4 and his signature thereon. He had also exhibited the seized dao and chadar as material exhibit 1 and 2 respectively. Post op. In his cross-examination, he had stated that on the date of incident, he was at Kuch Bihar and did not see the assault and could not say where the incident took place. So he had denied that. In his statement before the police, he had stated that the incident took place inside the house. He had arrived on the next date of incident of assault and signed the scissor list. He had also stated that the police had recovered the dao within bracket material exhibit 1 from the roadside ditch and cannot say to whom the dao belonged or how it was lying in the ditch, which was outside the house of the compound of the appellant. And that he had not seen seizure of dao from inside the house of the appellant. Next paragraph. Apurva Hazarika, APURBA Hazarika, was examined as PW7, was stated that the appellant was his co-villager and the deceased was his wife. Stop. He's a hearsay witness, but he had stated in the examination in chief that on 13/3/2016, when he had gone to the residence of Jiban Saikia, he heard from the wife of his late Jiban Saikia, late Jiban Saikia from Makan Saikia, MAKN Saikia, wife of late Jiban Saikia, that on previous night at about 10-11 p.m., the appellant had killed his wife, was later on taken to Joysagar Hospital. He stated that while he was in the residence of Bhupen Saikia, to take stock of the incident or death of Putuli, Amguri police had arrived at the residence of the appellant and they had seized one chadar from the roadside ditch in front of the house of the appellant. He had not seen the seizure of any dao, but he had heard that dao was seized from the said ditch. He had exhibited the seizure list within bracket exhibit 4 and his signature thereon, and had also exhibited the seized chadar within bracket material exhibit 2. First, in his cross-examination, he stated that the incident of assault took place on the previous night, but he could not tell the date of the incident, and that he had heard that the administration had recovered the dao, and he had signed the seizure list at the place of occurrence. uh, on a perusal of the Caesar list within bracket exhibit 4, it is noticed that that a dhow with wooden null NE having length of about 1/2 cm
Next
was
page, next page, one plot support which is red. The next page,
length of about 1/2 cm and one cloth within brackets chadar CHADR fact which was wet were seized. Full stop. However, PW7 only claims to have seen the seizure of chadar and not the dhow. Then you come to Deepak Bora, DIPAK, Bora, BURA, where it was examined as PW8. He knows the appellant as a co-villager and the deceased as the wife of the appellant. First of all, he had stated in his examination in chief that on the next day, morning of the incident, the neighboring people, including one Mr. Barua, had informed him that the appellant had killed his wife and had asked him to go to one police personnel of the village. And after the arrival of the Gambura, he went to the residence of the appellant, and saw her lying in the courtyard with multiple injuries. And the Amburi police had arrived at the residence of the appellant, and the police had sent him and the Gambura, Suchen Saikia, with the injured to the Joysagar hospital. The victim was admitted to the hospital, and after some time, Manas within bracket PW1 had arrived, and that the victim had died in the hospital during treatment. In his cross-examination, he had stated that he had not seen the incident and could not say the name of Mr. Barua. And he also could not say whether Barua is his name or his title. And he had also stated that the villagers did not maintain any relationship with the appellant or his ill temperament. And however, he had denied that due to ill feeling for the appellant, he had divorced falsely. Next paragraph. Gangadhar, GNGADHAR, Gangadhar Lahon, LAHON, was examined as PW9. Full stop. We will continue at 2.
I have a Padhar meter, may I leave them?
The notings on the recovery of the dhow, I couldn't get. I'm taking help from my learned friend. The notings on the recovery of dhow. Couldn't get in the recordings, I mean the entries. Anyway, my learned friend is seeing her. That's not a 27.
Just notice the original Caesar list. Please see the original Caesar list. Maybe it is in Assamese
Yes.
because the description of the weapon of assault which I just dictated makes it impossible for the 1.5 cm null to hold a dao.
1.5 cm now.
Null is a handle. 1.5 cm handle will not hold a dao.
The long one.
I don't know, it says 1.5
One
cm.
dao with wooden null length around 1.5.
CM.
1.5, he meant the entire thing or only
1.5 cm.
cm
Don't miss that word.
centimeter.
1.5 cm is this much. It will not hold. It will not
Probably
hold
it-
that.
Yes.
Find out from Assamese.
That's. No, in the original thing is also cm. Cannot be LM, it's a cm only. Strongly written.
So well, you have so many things uh, to discuss with your counterparts and inform the police administration.
So many things.
Perhaps the policemen took with them the scale of Latmandal. You have seen that scale? You have seen it?
Yes.
Yes or
I've
no?
seen- I've seen in my own when they had measured my own property, I had seen.
Okay. So this is this much.
This much.
So there 1 centimeter would be too long. So maybe they caught hold of
That-
Latmandal's scale. Gangadhar Ahon was examined as PW9. He was posted as an attached officer at Amguri police station. On 13/3/2016 at about at 4:50 a.m. The then duty officer had received an information over phone from Jintu Niog. Within bracket CW1. Constable of Assam Police regarding murder of the deceased by the appellant with a dao at his residence. Accordingly, Amguri PS GDE number 336 dated 13/3/2016 was made and he was entrusted to proceed to the place of occurrence and investigate the matter. Full stop. He reached the place of occurrence at 5:30 a.m. and found the deceased lying inside, the victim lying inside her house in an injured condition. Full stop. By then, the Gambura and others had arrived, and ambulance had also arrived there. He saw cut injury marks on the victim, and accordingly, considering the seriousness of the health condition of the injured, she was sent to Sivsagar Civil Hospital, Joy Sagar, with Gaur and few other villagers. Full stop. The in charge Joy Sagar informed at about 7:30 p.m. over phone that PM within bracket you write sick, SIC, should be AM, bracket closed, that the victim had expired at hospital. Full stop. Was inquest done? 55. 7:30 AM. He had stated that at 8:40 PM, within bracket sick, mentioned as (11 AM) in the inquest report within bracket exhibit 2. Inquest on the dead body of the deceased. He had exhibited the inquest report as exhibit 2 and his signature thereon. He issued requisition for postmortem examination and recorded a statement of witnesses in the hospital. And after handing over the dead body, he went back to the Amburi police station. The officer in charge of Amburi police station received the FIR at 11 AM on 13/3/2016 from Manas Kalita within bracket PW1. And he was entrusted to make further investigation of the case. Stop. He had stated that the appellant in his statement had stated that due to frequent quarrel by his wife on 13/3/2016 at about 4 AM, he had cut his wife with a dao, and thereafter the dao was thrown in a nearby ditch having water. Full stop. Thereafter he had gone to the place of occurrence and recovered the dao as stated by the appellant, and a cotton chadar, CHADR, was also seized. And he had exhibited the seizure list within bracket exhibit 4 and his signature thereon, as well as the dao within bracket M exhibit 1 and chadar within bracket M exhibit 2, material exhibit. So he drew the sketch map, recorded the statement of the accused, as a statement of the witnesses, corrected the postmortem report, and on completion of investigation, charge sheet was submitted against the appellant under section 302 IPC. Charge sheet within bracket exhibit 6 was submitted against Sansu, and he had also exhibited his signature thereon. Full stop. The statement of the appellant recorded under section 161 CRPC was also exhibited as Exhibit 7. His signature also exhibited. In his cross-examination, PW 9 had stated, just the IO within bracket, PW 9 had stated that he had not made the GD entry number 336 dated 13/3/2016 as a part of charge sheet, and the same was not tagged with the FIR, and had not referred to the said GD entry in the charge sheet. He stated that in the FIR within bracket Exhibit 1, bracket was, there was no mention of the name of the appellant as murderer of his mother. And in his statement also, he did not implicate the appellant as the assailant. He had not examined Jintu Niog, on whose information the said GD entry was made. And he denied that no information was received from Jintu Gogoi, or that the said GD entry was a concocted one and made after completion of investigation. You have that, just checking the records. The time or the date when it was seen by the magistrate, is it available in that GD entry?
Entry time is there, but.
Has to be. Just with the LCR. That is Exhibit 2, just check it up.
From the exhibit, right?
It was in my. Leak pad doesn't have.
Twenty-one six.
Huh? $21,600. No,
5/7.
5/7 is the sessions court. That is a session judge. No, that means he is right. You see, the GD entry was never made a part of the trial court record, only that much. This will show that the GD entry, the GD extract of GD entry was not made a part of trial court record. Because if anything goes into the trial court record, then the Elaka magistrate will see it.
Like it is done hereby.
He will mark it as seen. So he had denied that the appellant had not confessed his guilt before him. He had not sent the appellant to court for recording his statement. He did not know how deceased Chadar was related to this case. And he had not verified as to whom the Chadar belonged. He had also stated that in the seizure list within bracket Exhibit 4, there was no mention that the seized articles were recovered on information by the appellant, as informed by the appellant. And then there was a mention that the same were recovered on being shown by the witness. he has also stated that in Exhibit 4, the place of seizure was shown as the place of accused, public appellant. And there was no mention that the seized articles were recovered from the ditch. First one. PW9 was, next para, PW9 was re-examined. Pursuant to the order of the court, he had appeared with the GD entry book containing, he said GD entry number 336 dated 13/3/2006. And he had exhibited the GD entry book within bracket Exhibit 8 and the relevant entry as well as true copy thereof, including the signature of the inspector and officer in charge of Amguri PS. First of all, he has stated that the said entry contains information that on 4:50 AM, information was received over phone from Jintu Niog, constable of Assam Police, regarding murder of the wife of the appellant by the said appellant at Kemdoi, KEMDOI, Kakoti, KAKOTI, Gaon, with a dao at his residence and fled away. And that it also contains a remark that after making the entry, he was entrusted to proceed with the place of occurrence and investigate the pattern. He had stated in his cross-examination that in the FIR there is no mention that the appellant had assaulted the deceased with a dao. Next paragraph. Jintu Niog was examined as CW1, who knew the appellant as a co-villager and the deceased. He had stated that on 13/3/2016 at night, late night hours, while sleeping at his residence, he heard some hue and cry. And some village boy came to his house and informed him that the appellant has cut his wife. He asked them to go to the Gambura, who came to his house after some time. First off, he had informed he informed Gangadhar Lahon, PW9, of Amburi PS, and informed him that the appellant had cut his wife. And he had also gone to the house of the appellant and saw the victim lying with bleeding injuries, and she was alive. He had called the ambulance, and by that time, PW9 had arrived there, and the victim was sent to Joysagar Hospital by ambulance. And he heard that the deceased had died on the same day. Stop. In his cross-examination, he had stated that he had not seen the incident of assault, and he had named Rajan Kalita within bracket PW5 and Pavitra Kalita of his village of informing him about the incident. And he had no personal knowledge about the incident. He has stated that the IO, in course of investigation, did not record his statement. Next, on conclusion of the evidence of the prosecution as well as CI. So CW 1, the applicant was examined under section 313 CRPC. Which has already been referred here before. Next para. The next para, the learned session judge, Sivsagar, by the impugned judgment, by the judgment impugned in this appeal. No, not that. It's like that. You say that the learned session judge, Sivsagar, appreciated the evidence of the witnesses. And held that in his examination under section 313 CRPC, the appellant had not denied of inflicting injuries on the injuries received by the deceased. It was held that the explanation by the appellant confirmed that the deceased has received injuries on her face and head and subsequently succumbed to her injuries. And accordingly, in view of the statement of the PW2, the medical officer, that injuries as mentioned in postmortem report within bracket exhibit 3 can be caused by material exhibit 1, thou. It was held that the said injuries was caused with an intention and knowledge to cause death. And accordingly, the death of the deceased was held to be homicidal in nature. Stop. It was held that the chain of circumstances available in this case being number one, the accused and the deceased, sorry, the appellant and the deceased used to reside in the same residence, and on the date of incident, there was no other person present in the house of the appellant. Semicolon number 2. Soon after hearing hue and cry, PW5, we went there and saw the victim lying in injured condition. And he had informed the matter to her son, who used to reside at Joysagar. Semicolon number 3. And the appellant had fled away from the place of occurrence. Semicolon number 4. The surrendering of the appellant at Ampuri police station semicolon. 5. Informing the police about the place where he had thrown the weapon of assault and subsequent recovery of the said dhow from the place by the police. Semicolon. Thereafter and then write giving false version and within bracket 7 giving false version in 313 CRPC examination. First one. Next, placing reliance on the ratio laid down in the case of Sharad, SHARAD, Birdhichand, BIRDHICHAND, Sharda, SARDA, versus State of Maharashtra, comma, within bracket 1984, bracket 4 SCC 116, comma, relying on, comma, it was held that the chain of circumstances prove the offense and guilt of the appellant. For which reliance was placed on question number 15 during examination of the appellant under section 313 CRPC, which is stated to be a proof that the appellant and the deceased used to reside together and their children used to reside separately. And that the appellant had 2 wives and his other wife resided at Titapur with her children. First one. Though the PW1 has stated that he lived separately from 5 to 7 years from his parents, he denied having strained relationship with his father. And accordingly, it was held that even assuming that the informant and the appellant had some sour SOUR relations, that would not give any reason for killing the appellant, killing the deceased. It was held that none were present, that no other person were present in the house during the incident of quarrel. Reference was made to the cross-examination of PW 5 and 8 that due to ill temperament of the appellant, the villagers did not maintain any relationship with the family of the appellant. And accordingly, it was held that except the appellant and the deceased, no other person was present in their residence. Full stop. Next paragraph. Trial court. Had held that PW5 on hearing hue and cry at about 4:30 AM came and found the deceased lying with injuries at her neck, face, etc. And gave information to their son, Marash Kalita with the PW1. Which was found to be corroborated with the evidence of PW1. And it was held that the PW3 was also stated that he had heard the letter from one Deepak Bora. In bracket PW8. And came to the residence of the appellant and saw the deceased in injured condition. It was also said that Deepak Bora within bracket PW8 and Jintu Niog within bracket CW1, where police constable residing in the same village has stated that at early morning hours of 13/3/2016, they were informed that the appellant had cut Utari Kalita and saw the deceased in an injured condition. The information given by CW1 to Angori police station was found corroborated by the evidence of SI Gangadhar, GNGADHR, Lahan, LAHN within bracket PW9. Regarding receipt of information by phone from Jintu Nyok within bracket CW1, a police constable of Assam Police regarding murder of the deceased by the appellant, which led to recording of GD entry number 336 dated 13/3/2016. It was held that the PW9 in his re-examination had proved the original GD entry number 336 dated 13/3/2016. First, by referring to the GD entry number 336 dated 13/3/2016 within bracket exhibit 8, it was held that a clear information of murder by the appellant was mentioned there. And accordingly, it was held that the first information report, that the GD entry was the first information report leading to a cognizable offense. And referring to the evidence of PW5, it was held that the residence of PW5 was on the backside of the appellant, and he heard a hue and cry and came to the house of the appellant, who was his uncle. So accordingly, it was held that there was no other view possible other than the appellant inflicting injuries on the deceased at his home. The act of the appellant to go out of his house to bring a vehicle to take the injured to hospital, went directly to the police station, was held to be fact proving the guilty mind of the appellant. Full stop. The full stop. Emphasis was laid on the recovery of the dhow within bracket material exhibit 1 pursuant to the seizure memo within bracket exhibit 4, which was recovered from the roadside ditch outside the compound of the appellant. Were held to be relevant under section 27 of the Evidence Act regarding leading to recovery in the presence of the appellant. Leading to recovery. And his statement wherein the appellant had stated that he had thrown the dhow into a ditch and recovery of the same, according to the court, had established that the appellant had the knowledge where he had thrown the dhow. And this was also held to be a circumstances against the appellant. Ms. Jan, please come to page 51.
Have the paperwork, Lordship will what?
You take this.
I can take out from the case records. I can take out from the case records.
Okay, this is the judgment.
Huh.
Internal page 19 of the judgment. Pages are down below.
90, yes.
Yes, 19, paragraph 34, first paragraph.
Yes.
Now he says, out of 5 lines, sixth line, the accused has taken an alibi of returning home at 5 p.m. from Bihu festival, but did not bring any witness to show his presence at Bihu field. Bihu was never there.
I'm sure it was a Gita, Bhagavad Gita,
Bhagavad,
and
No.
not 5 p.m.
not
it is
5 p.m.,
a.m.
could not be, has to be 5 a.m.
PM. It's wrongly written.
Just right in this. So, although in para 35, 34 of the judgment, it has been recorded that the appellant had taken a plea of alibi of returning home at 5 p.m. from View Festival. But he did not bring any witness to show his presence at View Field in closed. But it appears to be a error in recording of the time and festival, because the appellant was arrested on 13/3/2016 at 11 a.m. and that he had taken a plea of coming home from at, he did not say morning 5 a.m. He does not say.
He said 5 a.m. I returned.
Okay, 5 and that he returned from at 5 a.m.
I returned
from
home.
Bhagavad Path. Full stop. The non-examination of Koli, Koli, Kalita, to whom he had informed was not examined as defense witness. And according to the explanation offered by the appellant, was held to be false. Full stop. Next paragraph, therefore, comma. As the appellant and the deceased resided in same house, and after hue and cry was raised at 4:30 a.m. on 13/3/2016, comma, the villagers, including PW5, had arrived at the place of occurrence and found the deceased in an injured condition. Arrival of the Amgori police station personnel within 1 hour, and and absence of the appellant at the place of occurrence, and his subsequent surrender in the police station by giving statement of where he had thrown the weapon of offense and recovery thereof from the said place, was held to constitute a complete chain of circumstances against the appellant. Accordingly, it was held that the appellant had committed the murder of his wife, the deceased, by a thou. So, nature of injuries. Was held to be showing brutality on part of the appellant in causing the injuries, and that after causing injuries, he had left his wife in an injured condition and ran away from the scene of occurrence. Was held to show the guilty mind of the appellant and his intention of causing death of his wife. And accordingly, it was held that the appellant, with full knowledge and intention, had caused death of his wife, Putri Kalita. Full stop. And accordingly, he was held to be liable for punishment under section 302 IPC. And accordingly, he was held guilty of committing offence under section 302 IPC. First off, he was heard on the quantum of sentence and was awarded imprisonment for life for committing offence under section 302 IPC and to pay a fine of Rs 1,000 with deposit stipulation of undergoing simple imprisonment for 1 month. Okay, we stop here. The appreciation will do it. Perhaps we'll be putting the orders tomorrow, maybe afternoon and evening. Oh, just one minute. Just continue. Next paragraph. According to the learned Amicus Curiae, her legal aid counsel, she has submitted that the evidence of the witnesses are not consistent to prove the guilt of the appellant. And that there is no clarity of the person who had first seen the occurrence or the person who had first seen the deceased victim in an injured condition. And that information was lodged by PW1, who is a hearsay witness. First of it is also submitted that the weapon of assault was not sent for forensic examination to find out if it contained human blood residue. First of it was also submitted that the victim was initially initially said to be lying in the courtyard of their house, but as per the IO, the victim was lying inside the house. It is also submitted that the seizure list is in difference with the evidence of the witnesses, as the witnesses, including the IO, had stated about recovery of knife from the ditch outside the house of the appellant, whereas as per the seizure list within packet exhibit 4, the dagger was seized from the place of occurrence, which is inside the house. And for referring to the place of occurrence, the sketch map within bracket exhibit 5, bracket close, was referred to. So it was also said that the appellant was not flying away from the police, but he had voluntarily gone to the police station to inform the police station about the incident, but he was arrested. And accordingly, it is something that the guilty mind of the appellant cannot be presumed. It was also submitted that the prosecution did not prove that the dog belonged to the appellant. And accordingly, it is submitted that he was framed for the murder of his wife due to previous animosity between the appellant and his son with comma Manash Kalita within bracket PW1, against whom the appellant had filed a case of property dispute. So it is also submitted that the victim had apparently had allegedly been assaulted at 4 a.m. and was lying in an injured condition. But none of the witnesses or the IO has stated that that she was in a condition to speak. And therefore, the evidence of the PW1 having heard from his mother that she was assaulted by the appellant cannot be believed. Because during the intervening period, a lot of people, including the Gaonpura and the police, had visited the place of occurrence and had an opportunity to interact with the deceased. That's
Yes.
property dispute as well as family dispute between the two families of the appellant. Stop. Next part. Per contract, the ABP has submitted that the chain of circumstances were complete. And it was submitted that the Learned Trial Court had correctly appreciated the evidence on record. In view of the complete chain of circumstances. First of all, it is submitted that the she submitted that Rajan Kalita, within bracket PW5. Had heard a hue and cry at the residence of the appellant at about 4:30 a.m. and informed the informant, namely Manas Kalita, who had come from Joysagar to the hospital where the deceased was, where the victim was taken. And he had also not, and the PW5 also did not find the appellant in his house. Full stop. The so it was further submitted that there was a quarrel in the intervening night of 12/3/2016 and 13/3/2016 between the appellant and the victim. And it is submitted that all the witnesses in unison have stated that the appellant had killed his wife.
And other circumstances like her body in the courtyard.
Okay,
Then,
and first of moreover, it is submitted that the other in other circumstances, like the body found within the premises of the house of the appellant,
an
i.e.
appellant was
in
missing.
courtyard, as inside the house.
Appellant was missing, he was not found.
Pardon
Then
me?
dying declaration, appellant was missing, he was not
Okay.
found.
The-
Then dying declaration, then incorrect explanation, these are the circumstances.
The dying declaration by the deceased of the victim before PW1. And the recovery of the weapon of assault on being led by on being informed by the appellant were all circumstances which completed a chain, which leads to no other conclusion that except that the appellant was the perpetrator of the crime. Okay, please stop it here.
Number 2. Number.
I think we'll take up a pattern matter that
Upgraded items.
Upgraded item 8.
I don't think we'll have time to take up other matters. This is a pattern matter. Pardon me? Yes, yes, because we may not have time. Even if this falls matter, we won't have time to start a matter and complete it. So we are not taking other matters. It will be, dates will be given.
Well, just one favor. So far, item 2 is concerned. Next week, I'll be out of station. Only 2 days. So that it will not
Okay.
come.
Okay, next week, nahi boy, item 2.
Item 2.
List on so next week, nahi boy.
Not next.
All these dates will go in April.
Right.
These days, in these days, we'll not be able to fix because of intermittent holidays and then the bench is up to tomorrow. So
Oblige.
8.
Hello, the last occasion, day before yesterday, I was referring to section 180 of the Municipal Corporation Act. The under section 180, the incidents that are chargeable I think for the purpose of trade license, these are only three eventualities, namely the profession, trade, or calling. Now, neither of these three expressions have been defined in the Act. If your lordship will kindly have a look at the definition clause, section 2. Sorry, section 3.
Yes.
Lordship will have this section 3. In this section 3, these three expressions, neither of these three expressions are defined.
Profession takes,
Profession, trade, and calling. Neither of these three expressions are legally defined. Now, in that circumstance, my lord, the inclusion of the kind of activity that the members of the petitioner association have been doing, that is running educational institutions for the purpose of imparting education to the people, I mean the people at large. Whether that can be included within the meaning and purport of the particular word that is employed here. That is one aspect of the matter. And my humble and respectful submission on this point is that since it is not defined as what would constitute profession or what would constitute
because last known, historically known, not historically, it's called mathematically known, institutions which imparted education were in Mahabharata and Ramayana. Because they did not charge any fees.
Yes.
They were Gurukul system where all these great people had gone there and got their education.
now the Honorable Supreme Court has said that in the process of imparting education, there may be some surplus income because the kind of fees that are charged from the pupil that may generate some amount of surplus income, but it can never be understood to be a profit. And since that is not a profit, since it is not a profit-making activity, it cannot be called as a trade. But I'll come to that aspect of the matter. Now, neither of these three, because one of the plea that is very pertinent in the petition is that the previous versions of the Act did not have anything like Annexure 1. And that remains undenied. So, therefore, if the Annexure 1 was to be included in the Act, that can only be done by way of some amendment to the Act. or by issuance of certain executive instructions. The act is silent, act as we see in the form of the present publication. The act is silent on that aspect of the matter. And that silence is also very conspicuous by the absence of any pleading in that regard by the respondents. The annexure 1, your lordship has seen to the schedule 4. Fourth schedule, that will be at page 185. Fourth schedule will be at page 185, and 194 will be the annexure 1. Therefore, my respectful submission is this: without there being an amendment made to the provisions of the Act or to the schedule, by incorporation of this annexure 1 in publication of the Act as it is available now, it cannot be said that it's a valid.
You're relying on any other decision on that? You're supporting your submission with any judgments?
Not any judgment in this, because these judgments are known to your lordship, I need not supplant that. But only judgment that I'll be relying on whether the activity of the petitioners association, members of the petitioners association can be called as a trade. That I'll be submitting. Another aspect I would like to draw your lordship's attention to is, your lordship will kindly have a look at page 195 of the book, my lord.
Yes.
Last entry, advocate's chamber, serial 47, advocate's chamber. That was also included in the annexure. And your lordship knows there are judgments from the apex court also, of course, in the context of electricity.
No, this court passed an order staying it,
Yes.
but I don't think it's been decided, just
Because-
it's.
and my
I had joined KMC as a standing house in 2008. Around 2009, I found that the bar council had challenged this particular the advocate chamber. But it was with that particular two cases were filed, so those both two cases are dismissed for this.
Is it?
Yes.
But
It
I
was something-
remember there was an order of stay.
Thereafter, it is dismissed for this.
There was an order.
He will learn doing better because I remember that there was a stay.
The part two is.
Yeah.
Nobody attended. I was there in the.
But the reason may be, my lord, in between the year 2006.
No, but you see, advocate is also a profession and is also a calling.
Yes, but in the context, I'm saying I'll place that judgment to your lordship. Around 2005, 2006, there was a challenge to a decision of the Madhya Pradesh State Electricity Board to charge commercial rate of electricity, what do you call it? Commercial rate of duty on advocate's chamber. That was challenged before Madhya Pradesh High Court. Eventually, the matter went up to the Supreme Court, and the judgment was possibly by Justice Arijit Masaya, if I remember correctly, my lord. That was struck down. On the principle that the advocate's chamber cannot be understood to be carrying out any commercial activity. So maybe since that judgment had already come by then, I do not know why the bar council, the bar association had not pursued the matter, but this also remains one of the, laws here. Now, coming back to the provision itself, my lord, if your lordship will kindly see at page 184.
You refer to section 195 for what?
No, page 195, for the purpose of showing that page 195, for the purpose of showing that the advocate's chamber was also classified
Okay,
as
okay.
one of the areas where the requirement of trade license would be there. Now, coming back to the clause, the fourth schedule,
Yes, yes.
Schedule. The next year.
Yes,
so I basically put forth two limbs of argument. First argument is that in absence of any amendment having been carried out in the act, this could not have been incorporated, and therefore it is bad in law. This is number one. Secondly, my lord, even if it is assumed that this incorporation has been done in valid exercise of power, because in the writ petition, my lord, the challenge is on the virus of the provision. Even therefore, my lord, even if I assume that this has been done in valid exercise of power, the second limb of argument would be whether it hits the provisions of the Constitution, any of the fundamental rights of the Constitution guaranteed under the Constitution, or any of the provisions of the Constitution. That will be the second limb of argument. So assuming for a moment that this has been incorporated in valid exercise of power, in that case, my lord, the root of this provision lies in section 180, and 180 authorizes the municipal corporation to levy tax or requirement of trade licenses there. Now, what section 180 says, if we just come back to section 180, my lord, it says every person who carries in the city, either by himself or by an agent or representative, any of the professions, trades and calling. Your lordship will kindly mark these three expressions. Any of the professions, trades or calling indicated in the fourth schedule shall annually take out a license before the first day of April in each year, or within 1 month of his taking up the profession, trade or calling, as the case may be, and pay for the same such fee as is mentioned in that behalf in that schedule. This is also important. The last line, such fee as is mentioned in that behalf in that schedule. Now, if your lordship will kindly come back to the schedule, fourth schedule at page 184 of the book. Page
Yes,
184.
please continue.
Yes. Now, page 184 class 1 is relevant for us because the annexure 1 has been issued in relation to the class 1. Class 1 says company or association or body of individuals, the paid up capital of which is equivalent to 20 lakhs of rupees or upwards, and the trades mentioned in annexure 1. Now, if it is a company or association or body of individuals, then the paid off, there is a rider that the paid off capital has to be equivalent to 20 lakhs of rupees or more. And if these conditions are satisfied, then the next column for fees existing, which exercise or carries on any profession, trade or calling whatsoever, the amount is 7,500 rupees. That is statutorily fixed. So assuming for a moment that this annexure 1 has been incorporated in valid exercise of power, then also the maximum fees that is statutorily prescribed, that is 7,500. If the paid up capital is more than 20 lakhs. And alongside the description in class 1, the annexure 1 says at entry 11 that in private schools, this will come under the provision of class 1, I mean the fourth schedule, only if the number of students is above 300. Therefore, three eventualities are required to be satisfied before the authority asks me to enroll myself for grant of trade license. Number one, my paid up capital should be more than 20 lakhs. If I'm a company or association or body of individuals, the paid up capital has to be more than 20 lakhs. And the annual fee that I am liable to pay, that is 7,500. And this will come applicable to me only when, as an educational institution, I have a number of students more than 300. So if I am not somebody, I mean, if I am, my institution is not one which has enrolled a number of students more than 300, then I do not come within the purview of these provisions. This argument I am making, Lord, assuming for a moment, not admitting that they can do it in valid exercise of power. Now, if you're in the backdrop of this position, Lord, if your Lordship will kindly come to page 33 of the writ petition, the impugned order, which is challenged in the writ petition. Then your Lordship will find there a table, page 33. Page 33 of the writ petition. Page 33, there is a classification that if below 20 numbers of students, first of all, they have classified it as a trade. In the impugned notification, they have classified the activity as a trade. Whether or not they can do it, that's a different question, that I'll address your Lordship on this. But they have classified this trade on the basis of number of students intake. If the number is below 20, then the license fee per year is 1,750. If the number of students is above 20 and below 100, then it is 8,650. And if it is above 100 and up to 200, then it will be 17,300. Now, this classification, my lord, in my respectful submission, even if the annexure 1 has to be made applicable, it runs beyond the limit prescribed in the schedule code itself, because schedule code says, regardless of any classification, it will be 7,500. So, my lord, I think I have conveyed.
But you'll have to be fast because we can't spill over today.
No,
Because then if we are spilling it over today, then we are recusing.
I'll now just submit my lord, the two decisions.
No, we are telling you because the bench may
Yes.
not be there, so.
Therefore, my lord, this is the ambit of my argument. And to cut short the point, my lord, the necessary point of examination is only to the aspect whether the activity of carrying out educational institution, carrying out the activity of running educational institutes can be called per se as trade. Because neither it is profession nor it is calling. Because they have classified it as trade. In the impugned notification, they have classified it as trade, not as a profession or calling. So I'll have to show to your lordship that it is not a trade. The two decisions I'll be placing. Of course, my lord, there is a reference of these two decisions are in the writ petition itself. In paragraph 12, I have mentioned. Paragraph 12 at page 9. The first decision is 2002, volume 8, SCC, page 481. The first paragraph that I will read out to your lordship is paragraph 20, which is at page 533. May I?
Just. Paragraph?
Paragraph 20 at page 533.
Oh, we left rise. A single bench. Yes.
I'll just read it little faster. Paragraph 20, Article 19(1)(g). Perhaps. Perhaps you'll-
Oh, we'll have to rise. There's a single bench.
You can just read this.
I'll just complete this by paragraph 20.
Article 19(1)(g) employs four expressions: profession, occupation, trade, and business. Their fields may overlap, but each of them does have a content of its own. Education is per se regarded as an activity that is charitable in nature. See State of Bombay versus RMD Chamarbagwala. Education has so far not been regarded as a trade or business where profit is the motive. Even if there is any doubt about whether education is a profession or not, it does appear that education will fall within the meaning of the expression occupation. Article 19(1)(g) uses the four expressions so as to cover all activities of a citizen in respect of which income or profit is generated, and which can consequently be regulated under Article 19(6). In the Webster's Third New International Dictionary at page 1650, occupation is inter alia defined as an activity in which one engages or a craft, trade, profession, or other means of earning a living. Then, your lordship, next paragraph, in Corpus Juris Secundum, volume 67, the word occupation is defined as under. The word occupation also is employed as referring to that which occupies time and attention, a calling or a trade, and it is only as employed in this sense that the word is discussed in the following paragraphs. There is nothing ambiguous about the word occupation as it is used in the sense of employing one's time. It's a relative term in common use with a well understood meaning. Very broad in its scope and significance. It is described as a generic and very comprehensive term which includes every species of a genus and encompasses the incidental as well as the main requirements of one's vocation, calling, or business. The word occupation is variously defined as meaning in the principal business of one's life, the principal or usual business in which a man engages, that is, that which principally takes up one's time, thought, and energies, that which occupies or engages the time and attention, that particular business, profession, trade, or calling which engages the time and efforts of an individual, the employment in which one engages, and or the vocation of one's life, the state of being occupied or employed in any way, that activity in which a person, natural or artificial, is engaged with the element of a degree of permanency attached. Now, if your lordship will kindly turn to paragraph 25, the establishment running. The establishment and running of an educational institution. As your lordship, the establishment and running of an educational institution where a large number of persons are employed as teachers or administrative staff, and an activity is carried on that results in the imparting of knowledge to the students, must necessarily be regarded as an occupation, even if there is no element of profit generation. It is difficult to comprehend that education per se will not fall under any of the four expressions in Article 19(1)(g). Occupation would be an activity of a person undertaken as a means of livelihood or a mission in life. The above observations in Sodhan Singh versus Swans correctly interpret the expression occupation in Article 19(1)(g). Quickly thereafter, my lord, the next paragraph,
We have to rise.
at this, your lordship permits to continue tomorrow. ये तो दे दिए फिर कोई दिया था ना যদি হয় 23rd April खाली लास्ट टू बेंच नेक्स्ट प्लेयर है বুঝি পালা হবে না পেট ফিক্স করার দিকদারি হতো খালি যে নহব সেইটুকু মানে আননেসেসারি আপনার খালি মরব মানে মেটাল
It was a privilege. Paper, sir.
I've been missing part of it. That's fine.
But, what's a bit, my lord, what's in this case, my lord, AG is going to appear in this case. We can see, since it's a challenge for the virus, AG is going to appear. The AG is not available tomorrow, my lord. Let it come any other day, my lord. Tomorrow,
This bench would not be available then. That's why I asked you. But this bench, that's why I clarifically,
in the middle of it, only pointed out, my lord, the middle.
but this bench is not there after tomorrow.
So AG will not be available tomorrow, my lord.
Let it be listed. Tomorrow we make a prayer. Correct? Otherwise, the entire today's time is wasted.
Challenge for the virus, AG have to appear. That's the
Or
time.
otherwise, may I just suggest that if your lordship fixes up a matter on after the leave vacations. Because naturally, I mean, they will also have a sufficient time to collect with the date.
Okay, then you're right, that's right. The hearing remains hearing of the counsel for the appellant, petitioner remains inconclusive. Full stop. Next, at this stage, Mr. S. Bora Leonard, standing counsel for the GMC, has submitted that he is instructed that the learned advocate general would appear in the matter as the virus of the provisions have been challenged. Virus of the provisions of GMC Act has been challenged. Full stop. However, he prays that the matter be listed after view vacations. Full stop. Next para, as this bench may not be available after next week, comma, we release the matter from parted list on, give a date,
On 23rd April.
on 23/4/2024. Both sides are represented. Mr. Aikalita, learned counsel for the applicant, upon instructions has submitted that uh, that an issue similar to the present one, that an issue similar to the present one, which was heard and decided by this bench, is under challenge before the Supreme Court of India. So it is submitted that the hearing of the matter had concluded on 23/2024, and the verdict is reserved. So accordingly, he prays that the matter be deferred. Prayer is allowed. Let the matter be listed again. We make it after Bihu. What's the matter on? (24/4/2024). What on time I think it will go over. What was the apparent view of the court? Supreme Court, you're aware? No. Are you aware of the view expressed in court by the Supreme Court? No.